An initial appearance is a relatively simple hearing. However, a lot can happen there, so it's important to understand what may happen so you can be prepared. First, the judge will want to inform you as to what you've been charged with. They can do that by reading the charges to you in open court, or you can waive a formal reading since you've been able to read them yourself beforehand. Then the judge doesn't have to read those in open court. Second, the judge will schedule your next hearing. Depending on what jurisdiction you're in, sometimes it's called a waiver hearing, roll call, or decision to prelim. Third, the judge may advise you of certain rights that you have, such as your right to an attorney and your right to remain silent. Since you already have an attorney, the judge will leave that up to us. Your right to remain silent applies there because you're not required to answer any questions about the facts or the allegations that the state has made. Fourth, the state may wish to address custody. If they want to take you into custody and hold you pending trial, we will address that at the initial appearance. However, most of the time we know beforehand whether the state is seeking to hold somebody in custody before we go to the initial appearance, so we can prepare for that before we arrive. Fifth, the judge may require you to go get booked and released from the jail. That involves scheduling an appointment, going to the jail, going through the booking process, and then being released. This is in lieu of holding you in custody while your case is pending. As I said before, an initial appearance can be relatively simple. So talk to your attorney before you attend the initial appearance to determine which issues may arise at your hearing.